All righty. So today we're going to talk about the roadmap section. I want you to remember that the roadmap section is considered an introduction, but because most discussion sections, and you should have already determined this, are not a single subject, you need an introduction or a roadmap that ties everything together. Then after that, you're going to add point headings to guide the reader through the discussion. But having the roadmap section helps the reader see the structure of how your arguments relate to each other and ties everything together. So just as a reminder, every discussion about a client's legal question begins with an introduction. In that introduction, you're going to tell the reader the conclusions you have reached. You are going to explain the governing rule. You're going to dispense with arguments that you will not be addressing. You're going to indicate the order in which the legal arguments will appear. So as we first started and talked about weeks ago, your roadmap is going to state, explain, dispose, map, and then conclude with a transition into the subsections. Stated another way, your roadmap section should include an introductory sentence or paragraph that provides the context for the reader of what the case is about regarding your conclusion. Then it should include general rules that apply to all subsections, governing rules to the extent that they are different or supplement the general rules. Then you're going to talk about elements not at issue. You're going to discuss burdens of proof. And if there's anything that is related but not going to be addressed in the memo, you may need to tell the reader that, and then have a transition to your order or arguments. Remember that the roadmap doesn't have to be in this exact order, although it is usually traditional that you have an introductory sentence or paragraph first, and then you give the rules. But when you get to things like burden of proof or raise and dismiss, then it may change different orders. So what rules do you have? What rule governs the memo as a whole? Where does that rule come from? What helper rules do you have? And in this one especially, you're now dealing with the Fourth Amendment right to be free from unreasonable search and seizures. Do you have a policy that the rule serves? Because you're dealing with a constitutional right, are the rules going to be liberally or strictly construed? Because you are dealing with a criminal defendant, do you have any presumptions? Because you are dealing with a criminal defendant, who has the burden of proof? You are going to need all of that information, especially regarding your motion to suppress, in that roadmap section. So what goes in your rule statement? Governing rules. What applies to all subsections? Well, I already mentioned one thing, the Fourth Amendment. You know that you're dealing with a motion to suppress, so my guess is that probably needs to be in there somewhere. Considering you're in the state of Florida and this is a state case, the Florida Constitution probably needs to be in there somewhere. And then what other rules or statutes do you need? And then the helper rules. They describe how the courts interpret or apply the governing rule as a whole. Again, who has the burden of proof to prove a motion to suppress? When you're talking about presumption, when you're looking at the evidence or the court is looking at the evidence, whose favor does the court look at that evidence? And what policy is behind the unreasonable or the protection from unreasonable search and seizure? And are there any procedural rules that pertain to the entire question? All things that you need to think about. Remember when you do your governing rule that you're going to be like a funnel. You're going to describe from the broadest to the narrowest, making sure that in your roadmap section, the only thing that you are providing are rules that apply to the entire memo. So it also has to apply to both subsections. So you're going to describe how courts interpret the governing rule. You might have to explain a legislative reason behind a statute, burden of proof, how courts balance factors, presumptions the court may apply. And again, be careful. This is only the rules that cover the entirety of the memo. And you're going to provide necessary background information that the reader may need. So just to go over some things, remember Florida Rule of Criminal Procedure 30.190G is the Florida Rule of Criminal Procedure that talks about pretrial memos, and specifically G talks about motions to suppress. Remember that there are 5 different grounds for a motion to suppress. Only one of them has nothing to do with warrants. That would be A. Because you do not have a warrant at issue in your case, A is the applicable part of 3.190G. So you're going to have to determine whether or not the court will grant a motion to suppress based on A. Also, a reminder about the Florida Constitution. Florida Constitution, much like the federal Constitution, Fourth Amendment says that the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. It's important for you to remember that the Florida Constitution, as far as Article 1, Section 12 goes, specifically says that this right shall be construed in conformity with the Fourth Amendment to the United States Constitution as interpreted by the Supreme Court. Why is that important? Because the federal cases that interpret the Fourth Amendment regarding the right to be free from unreasonable searches and seizures are also binding and applicable to your case. Then don't forget about 901.1512, which is the Florida Stop and Frisk statute. That statute specifically says whenever any law enforcement officer of this state encounters any person under circumstances which reasonably indicate that such person has committed, is committing, or is about to commit a violation of criminal laws of the state, the officer may temporarily detain such person for the purpose of ascertaining the identity of the person temporarily detained and the circumstances surrounding the person's presence abroad, which led the officer to believe that the person had committed, was committing, or was about to commit a criminal offense. This statute does not violate Article 1, Section 12, or the Fourth Amendment. It was specifically enacted to put the Constitution part into legislative practice. So from the Stop and Frisk statute, there is now a cavalcade of law that discusses police encounters. Remember that the first question that you were asked to specifically address was whether or not this was a consensual or an investigatory stop, right? So how do you get there? Well, this is all from one Florida Supreme Court case, which says that there are essentially 3 levels of police-citizen encounters. The first level is considered a consensual encounter and involves only minimal police contact. The second level of a police-citizen encounter involves an investigatory stop as enunciated in Terry versus Ohio. At this level, the officer may reasonably detain a citizen temporarily if the officer has a reasonable suspicion that a person has committed, is committing, or is about to commit a crime. Sound familiar? Yes. This is the one that puts into practice 901.151. Consensual encounters don't implicate the law at all because they're not an unreasonable search or seizure. And the third level of police encounters involves an arrest, which must be supported by probable cause that a crime is or is being committed. Remember, the purposes of your governing rule is to set the standard, telling people what they must or can do, or what they must not or should not do, or what they are entitled to do under certain conditions. So based on this, you are going to have a group work assignment about the governing rule and the roadmap in general. These are the groups They've been assigned with your assignment, but these are the groups, so you know who was in your group with you. And for that group work, you have to answer the following. What goes in the rule statement for the roadmap section? Keep in mind that the rule statement in the roadmap has to apply to the entire memorandum, not just one individual subsection. I want that to be specific. I want to know what rule you're putting in, what case supports the rule that you're putting in, or if it's a statute or section of the Constitution, what section of the Constitution or what statute are you using? Don't just tell me that you need and recite the roadmap slide back to me. No, I want you to and your group to think about this and what goes in your governing rule and your rule statement as a whole. So what background rules do you need? What helper rules do you need? Are there any rules that you need before you get to more specific rules, starting as a funnel? And then I want you to determine whether any part of your rule is open and obvious and you need to dispose of it. And if there is, I want you to tell me what and what case or fact permits the disposal of that part of the rule. So think what goes into your governing rule. Remember that when you are writing rules, you write about the rules as they are today, not how they developed. I don't want a dissertation on the history of English law up to the Fourth Amendment. What applies today? Remember the funnel, describe broad principles before narrower principles. And remember to build bridges. The reader needs to know how one rule relates to the next. This is not basically putting in sentence form bullet points. Help the reader to see how the rules relate to each other. Create bridges between your rules. Remember that an easy way to create a bridge is by beginning the second sentence with an idea from the prior sentence. So make sure when you're writing your rules that you write about the rules as they are today, that you describe the broader principles first, and that you build bridges. And remember, depending on the applicability, your roadmap section should have an introductory sentence or paragraph, general rules that apply to all subsections, governing rules to the extent that they are different from the supplemental or general rules, elements not at issue, what open and obvious thing are you going to dispose of, if there is any, burden of proof, are there any related legal issues that the reader would say, why aren't they talking about that you need to address? And then you're going to have a map that gives the order of the analysis. For purposes of your group assignment, I'm not worried about your introductory sentence or your map section. I want to know what the general rules are, the governing rules are, if there's any elements or issues or elements or any rule that's not at issue, what the burdens are, and any related legal issues that you're not going to address in your argument. I look forward to seeing your group assignment. And on that, thank you, and I will see you on Monday.